All right, so I'm Ferrannini, and I'm here with Liz Stallard, and we're employment partners at Downey Brand, as you probably already know. And so we're going to be talking about a number of very new things and sort of new things to let you know what's going on as of today. Just a couple of housekeeping items. If you have questions, please use the Q&A. We'll probably hit that at the end to answer questions. We're also recording this webinar, so we'll post it to the website along with the slide deck, and you will be able to go back and look at it if you so desire. And if you need anything, please email Mary Isley, and her information should be on all of our materials, I'm assuming. So with that, we will get started. I think. Maybe we won't. All right. So today's topics, we're going to talk about COVID-19, and this is the February 10th, 2022 edition, because as you know, this is changing like by the minute. And so we're current as of February 10th, which was yesterday. We're also going to talk about some wage and hour issues, discrimination and harassment, claims and settlements, pretty much all of the fun things that we tend to talk about. So first, we're going to start with COVID-19. And the first thing we're going to start talking about is SB 114, supplemental paid sick leave. This was signed on February 9th. And you're supposed to begin providing leave as of February 19th, though that is a bit of a misnomer because this law is retroactive to January 1st. And it will expire on September 30th of this year. So this law is super current, super new. And so you should be looking out for notices and guidance from the labor commissioner regarding how this is going to be implemented. It's a little bit different. It adds Labor Code section 248.6 to the Labor Code. It applies to employers with 26 or more employees. There's special provisions that relate to firefighters and in-home support services. I'm not going to talk about those special provisions today. So who gets supplemental paid sick leave? Covered employees. And a covered employee is an employee who, very important, is unable to work or telework for a number of reasons. So you still have that telework option, remember. And really one of the biggest, two big changes to this law that make it different from what has gone before is that it applies to employees who have to take time to deal with their family members, and it applies to vaccines and boosters. So that's a big difference between what went before. So covered employees are employees subject to quarantine or isolation orders for all of those reasons, you know, from all of those departments and governmental officials and doctors that have been making such orders for the last 2 years. Or if the employee is caring for a family member that's subject to isolate or quarantine order. And a family member is a child, grandchild, parent, grandparent, sibling, spouse. Also, if they're attending an appointment for themselves or for a family member to get a vaccine or booster. If they're experiencing symptoms or their family member is experiencing symptoms from a vaccine or booster that prevent the employee from being able to work or telework. If they're experiencing COVID-19 and is seeking a medical diagnosis, or if they're caring for a child whose school or place of care is closed. So some changes, some the same as before. The maximum hours that they're entitled to is 80 hours. And there's kind of two batches of 40 hours. So they get up to 40 hours if they test positive for COVID or if their family member tests positive for COVID. So that's additional SPSL under the law. And then the regular SPSL is up to 40 hours for the other covered reasons. So quarantine, isolation, vaccine, experiencing symptoms, seeking diagnosis, school closure. Those are in a separate 40-hour place. And so naturally you ask yourself, well, what if they test positive for COVID and they're ordered to quarantine or isolate? That implicates both banks. So we don't know the answer to how you should characterize that. And so that's why I'm saying that it's important to keep an eye on the guidance that's coming out probably within the next week or so. The maximum pay is capped. And so keep that in mind. And a burning question for many employers is, what can I require as proof of all these things? Which is always seems to be one of the questions that we get asked the most regarding any kind of leave is, you know, what can we ask for to make sure that this is true? So the main verifications that you're entitled to, first, if they're taking the leave for a vaccine or booster, you only need to give them 24 hours or 3 days for each event. So Moderna 1, Moderna 2, booster, you can, for each one of those events, you can limit them to 24 hours, except if an employee is receiving or experiencing bad reaction, continuing symptoms, then they can get a certification for a healthcare provider to get more than the 24 hours or 3 days of leave for each event. If there is a COVID positive employee or family member, you may require documentation of the test result. And if the employee refuses to provide that documentation, the leave could be denied. But of course, always, before ever denying anybody anything, be sure that you talk to an attorney about the particulars of that case. And if you have a COVID positive employee or family member, you may require the employee to take another diagnostic test on or after the 5th day after the first test, and then to provide you with the documentation of that. You have to pay for that, obviously. But those are the things that you can require. And it's kind of a big deal to me because it is affirmatively saying that you can ask for testing, which is nice, finally, under the law. Okay, calculating the leave. This can get dicey with respect to people that have weird variable schedules. So I'm not getting into that today. But for full-time employees, it's 40 hours or based on an average of the time they were scheduled to work in the 2 weeks preceding the leave. Non-full-time employees, it's based on their normal regular schedule to work over 1 week. The pay rate for non-exempt, there's 2 options. You either calculate in the same manner as the regular rate for the work week in which the employee uses the SPSL, excluding overtime, or you can divide the employee's total wages, not including overtime, by their total non-overtime hours worked in the full pay periods occurring within the prior 90 days of employment. And if they work on a piece rate commission or something along those lines, you just use all of their hours to determine the regular rate. And exempt employees are fairly, a lot less complicated, same as other forms of paid leave. As I mentioned at the beginning, this law is retroactive because, of course, it just was signed 2 days ago and we're already into February. So it's retroactive to the beginning of the year. Employees may request retroactive payment for covered leave. And if they do so, you're allowed to require documentation of a positive COVID-19 test for the relevant period of time. And if the employee was not compensated in an amount that is equal to or greater than what they would get out of the SPSL, you have to true it up if they ask. And if they were paid an amount equal to or greater than the SPSL, you have to credit the SPSL to the absence rather than the benefit that was used. And as a general matter, the employee has the option of deciding what type of leave they wish to use. So the SPSL is in addition to any paid sick leave. It can't require the employee to use other paid or unpaid leave before using this benefit. It also interacts with the Cal OSHA ETS, which we'll talk about in a moment, because you may recall that under certain circumstances, you need to pay employees if they're excluded from the workplace under the ETS. So if the ETS requires the employer to maintain earnings, employers cannot require the employees to exhaust the SPSL first. Employees can choose to do so. As I noted too, there's going to be new notices that have to go out. The new poster should be available by February 17th, and it should be posted in your workplace or emailed to your employees. And there's a new pay stub requirement. And of course, it's not the same as the pay stub requirements that we've all been doing for the last several years. With this particular leave, you must report only the hours that the employee has used, right? Usually you're reporting what's available, how much is still left of their sick leave. Here, you're reporting only the hours that the employee has used. And you don't have to do this on a pay stub. You can do it on a ancillary document that's provided at the same time as the wages. And if the worker hasn't used any leave, you list 0 hours. All right, so that's the COVID paid sick leave.
Before you move on to the ETS, I wanted to read a question that came in on the Q&A to you.
Okay.
It says the new 80 hours, is that in addition to the 80 hours of paid COVID CARES Act leave paid out in 2020 to September 21?
That I do not know the answer to. Do you, Liz?
I don't, but my suspicion is it probably is more.
I suspect it may be more as well. And here's the other question, the other issue, because this is so new. I mean, it was just signed 2 days ago. If you have questions, you can feel free to email them and we can answer them for you. Because we've done a pretty in-depth look at the law, but there's still rando questions that we haven't thought of yet. So we'll go from there.
Oh my goodness, we're getting quite a few COVID related questions. I don't know, Cass, if you want to take them now, or maybe we'll do them at the end.
Yeah, let me do them at the end. All right, so just the ETS, and you guys probably are all familiar with the ETS, but some people aren't necessarily. And so I just want to cover the basics of what you need to know, just to make sure we're all on the page. So I'm going to talk about some of the definitions, the written program that's required, excluding employees, written notifications, and I'm sure that within minutes of us ending this presentation today, there will be a new ETS. So, but at least you'll have some understanding of what you need to do. And, you know, one way to think about all of this COVID stuff that you're supposed to do in the workplace is to think about it in the context of your IIPP, because the structure of it is very similar to what you have to do for an IIPP. It's a little bit more detailed, but if you just think about, okay, what needs to be updated in the same kind of categories that I have in my IIPP, you'll be good. Okay, so first, let's talk about definitions. Probably you know, a close contact is 6 feet for 15 minutes or more during a high-risk exposure period. A COVID case is a positive test diagnosis order or someone has died from COVID. And the high-risk exposure period is 2 days before until 10 days since first symptoms. And then it goes 24 hours with no fever and improved symptoms. And the situation with the fever, obviously, if you take an Advil or Tylenol, that doesn't mean you have no fever, right? It has to be fever-free with no medication. Fully vaccinated means that you have documented their vaccination status, right? So if you do not have any indication from anybody as to whether they're vaccinated or not, then you must treat them as unvaccinated for all these rules. You're supposed to have in place a written COVID-19 prevention plan, and the elements of that plan are on this slide. And as you can see, it really does kind of correspond with your IIPP correction of hazards, training, all of that stuff. And these are the elements that you need to have in that plan. When do you exclude COVID-19 cases and close contacts? So all COVID-19 cases are to be excluded. All close contacts are excluded except for fully vaccinated employees with no symptoms, COVID-19 cases who return to work and have remained free of symptoms, COVID-19 cases who never developed symptoms. So anybody who's not excluded but fits in those categories have to wear a face covering and maintain social distance for 14 days following the date of contact. Of course, the face covering situation is in flux and will probably change on Tuesday, the 15th, because that's when the current statewide mask mandate expires. So if that is actually allowed to expire, then perhaps some of these rules will be modified. So as you know, probably you're required to maintain benefits for excluded employees at the same wages, etc. Now, there was an exception if you could demonstrate that the close contact was not work-related. And so, for example, if you have an employee that's been telecommuting for the last 2 years and they have not come into the office, you can demonstrate very clearly that the close contact is not work-related, generally. I'm saying generally. This rule is now modified by the supplemental paid sick leave law. You can't require the employees to exhaust that SPSL first. So just keep that in mind. And so the SPSL is going to apply regardless of where they picked up COVID if they're unable to work or telework. So that's an important thing to keep in mind. The return to work for COVID-19 cases are they can't return until 10 days have passed since their first symptoms and they're clear. And COVID-19 cases without symptoms can't return until a minimum of 10 days after the date of the specimen for the first positive test. Close contacts, the rules are 10 days have passed since last known close contact. And keep in mind that for people that are living with somebody that has COVID, they're in close contact for a long time. It's not just their first day of close contact that you're measuring from. Or 7 days have passed since the last known close contact and the person tested negative for COVID at least 5 days after the last known close contact. So this is going to work in conjunction with your ability under the paid sick leave law to do testing at least 5 days after the last known close contact. If these people return to work, they're supposed to wear a face covering and maintain social distancing. Another thing that you have to keep in mind, and maybe I'm a day late and a dollar short on this, because I know that in the last 2 months, everybody's been sending out notices of exposure probably every other hour to their workforce due to the Omicron. And that seems to now be on the decline. But there are certain elements that need to be included in your notice. And so I just want to remind you of those elements so that you can make sure that whatever you're sending to employers to notify them of potential exposure is compliant with the rules. And here's the content. And always of course, remember that you can't reveal personal identifying information. And that also, this requirement to tell them about their potential benefits is, you should probably start to include supplemental paid sick leave in your notices. All right, done with COVID for the moment, till the end. So wage and hour issues, because those are always fun to talk about. And again, there's always a minimum wage increase for the past several years. There's some expanded liability, and then we're going to talk about some cases that happened last year. So remember, state minimum wage has increased. So that is going to have to just make sure that you're paying the appropriate minimum wage. Always remember to check your county and city minimum wage ordinances, because pretty much every city in California seems to have an ordinance now. So make sure, and most of them are higher than the state minimum wage. So to the extent you've got employees all over the state, make sure that you're in compliance with those. And as always, the higher minimum wage threshold kicks up the exempt salary threshold. So be aware of that. And then again, that's going to increase again in January of next year. There's also a new exemption for computer professionals. It's an overtime exemption. So exempt computer professionals still comply with meal and rest break requirements. So this is simply an overtime exemption. There's also a new law, AB 1003, regarding intentional theft of wages, which is punishable as grand theft. And grand theft is punishable as a misdemeanor or felony by imprisonment for 3 years. This law defines intentional theft of wages, which is the intentional deprivation of wages. It's very rare in my experience that there is an intentional deprivation of wages. I think most employers, and I've dealt with a lot of employers, most employers are trying to do the right thing and are caught unaware sometimes due to the technicalities in the law. Also interesting about this law is that employee includes independent contractors, which is a novel concept. There's always been some misdemeanor possibilities in the labor code that could be enforced by the labor commissioner. And so this is kind of follows in the footsteps of that situation. There's expanded wage and hour liability for general contractors. Currently, the general contractor is only liable for unpaid wage, fringe, and other benefits and interests, but under SB 727, and this is for private works contracts, contractors will be liable for penalties, liquidated damages, and interest owed by the subcontractor. So make sure that your subcontractors aren't shady. That's the law of dealing with subcontractors. Make sure that you are aware of what they're doing, and make sure that your contracts have all the appropriate language from the labor code in them. There's a new case, Wesson v. Staples, which talks about unmanageable PAGA claims. And so just to kind of set the table for this, one of the things about PAGA claims, and PAGA is, let me back up, the Private Attorney General Act. And under PAGA, PAGA is a representative action. It's not a class action. and it allows a representative employee to bring a lawsuit to recover civil penalties on behalf of other employees. And one of the things that's very frustrating about PAGA actions is that it's not like a class action where the plaintiff has to make a certain showing to the court before the plaintiff is permitted to represent other parties. And so it's always been a little bit more difficult to eliminate PAGA claims. This case makes it a little bit easier to eliminate PAGA claims. And so it's a good case. Basically, this was a class action with 350 general managers who were allegedly misclassified as exempt. The court denied class certification. And so basically the case had been brought as both a class action and a PAGA action. The court said, one of the showings that you have to make in a class action is, if you're a plaintiff, is that it makes sense to try this. It's a manageable case. We're not going to have 350 managers up testifying. That's one of the things they have to prove. And so after the court denied class certification, Staples moved to strike the PAGA claim, saying that it was unmanageable, which is great because the court had already probably determined that in the context of the class certification motion. And the things that made it unmanageable were the difference in store sizes, sales volume, staffing levels, store hours, budgets, products, services. One of the things to make a class action run for a plaintiff is that all things are the same between all of the employees, and they're all treated the same in the commons policies, et cetera, et cetera. So if you can show that things are not the same and things are different, and the only common policies are lawful policies, then that can get you pretty far in defending claims like this. The trial was estimated to take 8 years to complete. So you can imagine that the trial court, looking at his docket in California, particularly after COVID, was not keen on taking 8 years to try a case. And so the court granted the motion. And that worked. So that's a good news for employers. I'm going to tell you also about this. This is an interesting case, Ms. Kanian. It's about a guy that was an in-house lawyer for AMI. AMI had active litigation, and AMI offers him his salary for being the in-house lawyer and also a bonus for being involved in this stern litigation. And they offered him a bonus for each month he worked on it and 10% of the recovery. And this agreement was never actually reduced to a signed writing. There was an agreement, and then there was a modification of the agreement that somehow snuck into the personnel file. Ms. Katie was like, wait a second, no, well, this isn't what we agreed to. And so the agreement was never actually signed. And of course, AMI didn't want to pay that bonus. So he argues that the bonus is a wage that needs to be paid. AMI argues the bonus is a contingency fee agreement because he's a lawyer. Now, keep in mind, this is a very, this case is really about the legal industry, or if you have in-house counsel. But the court ultimately agreed that this was a contingency fee agreement. The reason is because it was based on the outcome of this stern litigation where they would get 10%. And contingency fee agreements under California law need to be in writing. And so because it was not, Miskanian, a lawyer, couldn't enforce it, but he had all kinds of other claims. So don't worry. He has a way to get his bonus. He has other options for recovery, but it just kind of points up the fact that a lot of times it's very good to get everything in writing to make sure everybody's on the same page. All right, and with that, I will turn it over to Liz.
Well, hi, everybody. Again, as Cass mentioned, I'm Liz Stallard. For those of you who don't know me, I'm a partner here in our labor and employment group, and I'm going to walk through the last two segments of our seminar today. First, talking about discrimination, harassment, and retaliation, and then kind of our wild card bucket of claims and settlements. So first, discrimination, harassment, and retaliation. I guess before I start, I know we've had other questions coming in too. Feel free to keep sending those questions into the Q&A, and then assuming we get to the end of this and we have some time, or we'll work through any questions that come in regarding the topics we've addressed today. Oh, there we go. So today under this topic, three things that I'll be addressing: CFRA expansion. I don't know why we bother saying expansion because it never gets contracted. DFEH record retention requirements, and some notice posting questions for, moving ahead, some notice posting requirements for telecommuting employees. So first, with respect to the CFRA expansion, this assembly bill provides that the categories of individuals for whom leave can be available to take care of include parents-in-law now, effective January 2022. A parent-in-law is defined as the parent of a spouse or domestic partner. And so, somebody keeps changing my slides. All right, Cass, hands off the keyboard. All right, so the takeaway from this being, of course, presuming you have policies addressing CFRA leave in your workplace, we want to make sure that you know not only to update your handbooks, but also so that you understand that your practices need to be modified to address that kind of leave. Next, DFEH record retention requirements. As probably many of you know, over time, the DFEH, the time period pursuant to which someone can bring a claim, that statute of limitations has been expanded to 3 years. No surprise that now they are moving to make record retention requirements longer, consistent with that expanded potential claim period. So here's indicated before, employers are required to retain applications, personnel, membership, and certain employment referral records and files for at least 2 years. Most records have to be retained at least 3. Now, this Senate bill provides, effective this year, that the requirement is expanded to 4 years of retaining those records after they were initially created, or 4 years after the relevant employment action was taken. There's also other information or provisions in this bill requiring that when you receive notice of a DFEH complaint, you have to maintain and preserve those files either till the first date after when they could file a civil action related to that claim, or the first date after the complaint has been fully and finally disposed of, including appeals and related proceedings. As many of you know, those complaints often start with the DFEH and then move on to civil litigation. So you can imagine that can be a quite extended time period. Again, I think this is one of those things, if you find yourself with one of those claims and pursuant to how you would react to any potential claim, you want to think about your record retention policies, especially now that we've moved so much stuff electronically, right? To make sure that we're keeping track of those records for employees as well as applicants. Next, the final issue in this section about notice posting for telecommuters. Certainly over the last 2 years, many of us have been living in the Zoom world, although some perhaps with better facility with these PowerPoints than I've expressed today. SB 657 modified the labor code, essentially to confirm that if you have an obligation as an employer to physically post a notice or other information, you can also distribute it to your employees by email with that document attached to it, right? For your employees working from home, for example, who are not going to be seeing it in its traditional location. However, that's just a may in addition to obligation. You still have to post it physically in the required posting area. This is just a in addition, you can send it out by email. In some respects, this doesn't seem to be really a change because you certainly could have sent it out by email before. Punchline, this is an opportunity to make sure you're providing those notices by blasting them out to your employees electronically and not necessarily depending on them to see them in the physical workplace. And so now the final category, claims and settlements. So first, AMN Healthcare versus Aya Healthcare Services, Inc. is a case, federal court case, and this case has been going on for quite some time. By way of a little history, it focuses on non-solicitation provisions. So here we had AMN and Aya competitors. They both provided travel nurses to different medical care facilities. And in some cases, AMN, when it didn't have enough to cover all of its jobs, what a wonderful problem to have, it would send kind of rollover work to Aya as part of its relationship with it. in conjunction with having that relationship where it was exposing essentially IA to its resources and its clients, it had non-solicitation provisions with AMN, between AMN and IA, providing that they couldn't solicit AMN employees for at least a year after termination of the employment relationship. And again, as this notes, importantly, those travel nurses were considered employees, right? Even though they might be contracted and working these shorter periods of time. So back in 2018, we had a court say that non-solicitation provision was unenforceable. This was essentially a Sherman Act and antitrust case, but the court looked at standard provisions of basically competition law and found that under Business and Professions Code 16600, right, we look at unlawful restraints of trade, and here, consistent with California public policy, and we want people to have, free competition, you can't have this kind of non-solicitation provision, especially because these are entities that deal with recruiting, right? And so if you're basically putting a restraint on their ability to recruit, it's an unlawful restraint on trade. Right, so that's back in 2018. It gave a lot of us concerns about the ability to use non-solicitation provisions and them being worn down, much as non-competes have in the state. But now we have 2021, and here the appeals court comes back and says this non-solicitation agreement is not per se illegal, and in this case is also not unlawful under rule of reason scrutiny. Again, we're in the antitrust context, but it's important that the court confirmed that they could have this non-solicitation provision in effect, because it gives us hope that we can use these kinds of provisions in business-to-business relationships involving, shared resources and clients. So again, here, the concern previously was competition. In fact, the appeals court explains that it promoted competition to have this non-solicitation provision, because if it hadn't been there, AMN wouldn't have been so free to share this extra work, right, with its competitor and to engage in that kind of behavior in the marketplace. So it's almost flipping it on its head from what we'd had previously. It's also worth noting that this is consistent with some other things we've seen coming out of California courts. Again, because as I mentioned, this is a federal case, but we're getting some useful authority out there with respect to the enforceability of these non-solicitation provisions. And again, because we're looking not so much at 16600 and the unlawful restraints of trade, this kind of authority may help us to enforce those provisions in the event that you have this kind of relationship and you have concerns about protecting your competitive advantage. And so next, more limits on confidential settlements. These are some provisions that we wanted to make you all aware of with respect to when you're engaged in, severance and other kinds of agreements with your departing employees. Already, as of, from SB 820 went into effect and prevents us from imposing a confidentiality obligation with respect to factual information related to sexual harassment, sexual assault, workplace harassment, and discrimination based on sex claims. Again, as the Me Too movement generated a lot of this kind of legislation. Now we have SB 331, which expands that bucket of provisions that you can't require to be confidential. It's now expanding them to any protected class related to harassment or discrimination. So it's not just sexual harassment, it's also race discrimination, disability discrimination, every one of those protected classes. We're in that same situation in terms of you can no longer require confidentiality with respect to those factual allegations as part of a settlement with a former employee. And again, there are other provisions coming out of this with respect to your severance and settlement agreements. If you have used a non-disparagement provision, and I'm sure several of you are familiar with that, any provision that now includes any agreement that now includes a non-disparagement clause has to carve out as follows. Nothing in this agreement prevents you from discussing or disclosing information about unlawful acts in the workplace, such as harassment or discrimination or any other conduct that you have reason to believe is unlawful, right? And so again, this is consistent with that trend of trying to prevent, the employer, the contracting entity from keeping that information from being disclosed as part of the settlement. And of course, in a lot of cases, those settlements and separation agreements, the point of getting that release is to limit the kind of life of those kinds of allegations. These specific provisions now have to be incorporated into those agreements and limit your rights as an employer to do that. And then finally, with respect to separation agreements, there's also a requirement that you notify them they can consult an attorney, and also that you provide the employee at least 5 business days to do that. Employees can waive that requirement. Again, these are provisions to protect the employee when they're agreeing to waive rights. And of course, if you're in this kind of situation, where Cass and I are, And so hopefully if you find yourself having to craft an agreement, you're mindful that there are changes you need to make to what, your standard or template agreements that you've been using to date. Oh, and I guess, before I move on to this, I'll say I can beat Cass, and that something that came out 2 days ago, I have law that came out this morning that is so new that I can't even put it in the PowerPoint, which is, as some of you may know, that President Biden signed into effect today a law that prohibits you from forcing claims related to sexual harassment or sexual discrimination and assault from being forced into arbitration by employees. This has come out of, again, the Me Too movement. You had individuals like at Fox News who wanted to go after Roger Ailes. I think Gretchen Carlson has been a big figure in getting this law passed. But this idea that if you have a mandatory arbitration provision, you can't force those kinds of claims to be arbitrated. I believe, and again, it's hot off the presses, but that law looks at giving the employee the option to void that requirement and to proceed in court instead. And so certainly if you're dealing with that kind of situation, it's one more instance where we're looking at the limits of how you can use kind of standard practice provisions for these particular kinds of claims. And so I wanted to flag that as well. Again, that's what you get for coming to the presentation. You get to hear about it. It's almost impossible to keep up with all the laws that are changing literally every day in this area. And so now let's talk about Chamber of Commerce v. Bonta. This case, again, too, I'm sure, I think we're on year 2 of it, and I don't think we're done, or year 3. AB 51 is what started this. It banned the use of mandatory arbitration agreements with employees, and it imposed criminal penalties on employers for those efforts. It was supposed to go into effect on January 1st of 2020. There was a lawsuit filed by the Chamber to enjoin enforcement of it, and their argument essentially, it violated the Federal Arbitration Act in that it discouraged or limited the ability to use an arbitration agreement with the employees. In response to filing that lawsuit, the Chamber secured a temporary restraining order at the end of December, right before the law was going to go into effect. And that was followed soon after by a preliminary injunction, essentially keeping the law from being enforced while this played out legally. So that stay, that prevention of being able to enforce the law, was then appealed to the Ninth Circuit. On September 16th of 2021, we had a 2-1 decision come out of the Ninth Circuit that says that this law doesn't actually conflict with the Federal Arbitration Act, and California is free to prohibit these mandatory arbitration provisions. So I put in here that it's an odd result, but what's odd in part about the opinion, and it was something highlighted by the dissent, is that now, based on what this Ninth Circuit opinion says, if you go to your employee and you give them a mandatory or condition of employment arbitration agreement, and they sign it, it's valid and enforceable, and you can't be subject to any of the civil or criminal penalties. However, if you give them that same mandatory or condition of employment arbitration agreement and they refuse to sign it, then you're subject to the criminal and civil penalties that could result from trying to use a mandatory agreement in the first place. It almost makes no sense. The other issue with this decision, of course, and it was also pointed out in the dissent, is that we have 2 other circuits in the country, the 1st and the 4th, that have rejected similar kinds of laws as getting in the way of the Federal Arbitration Act's enforcement and public policy reason in support of arbitration agreements. So now we have these split circuit issues, and also we have these kind of odd results, as I explained earlier, based on the way that the court interpreted the application of the law. So in October of 2021, the Chamber filed a petition for rehearing in front of the Ninth Circuit, and that briefing just finished at the end of the year in December. And so that briefing it could take months potentially for that rehearing petition to be resolved. In the meantime, the law remains stayed, right, enjoined from enforcement essentially. So if you are an employer that uses mandatory arbitration provisions or even voluntary arbitration provisions, this is something you need to keep in mind. We expect, I assume we'll be talking about this case again next year at our annual update, and just to be mindful that there are some landmines out there with respect to using arbitration agreements right now, especially because we're in this period of uncertainty. The next issue on our list is looking at labor commissioner enforcement mechanisms, and this was put in place by SB 572. This particular law allows the labor commissioner's office to place real property liens against an employer's real property for the amounts due to the commission for citations and findings and decisions that become final and may be entered as a judgment. So what this does essentially is it doesn't make the labor commissioner have to go and get a judgment lien first. They can go ahead and place that real property lien. It speeds up their ability to enforce these determinations, and go after employers, to be perfectly blunt. It also really is just bringing the enforcement mechanisms in line with other efforts to do similar that happened previously. You look at Labor Code 98.2, they provided those real property liens for employee-related recovery. And so this is really just, again, kind of giving the labor commissioner all of this authority to very quickly enforce these judgments. So what's our takeaway? If you have a judgment entered against you, pay it quickly, right? Make sure that you have that you aren't subjecting yourself to these potential mechanisms for recovery, which have just become a lot more streamlined in recent years. And then this last case that we wanted to address today is Wasito versus Kazali. And let's start by, this is a case about 998 offers. And so just very briefly, a 998 offer, or rather it's a provision of the Code of Civil Procedure, section 998, is a mechanism that can be used, particularly by a defendant facing claims that allow for recovery of attorney's fees, to try and cap the recovery by sending basically a commitment to allow the other party to enter a judgment against you for a certain amount at any particular time in the lawsuit, right? So you can send that offer and they can enter that offer essentially as a judgment. If they choose not to accept that offer and they move on and they go to trial and they recover less than you offered them in the 998, then their attorney's fees from the point at which you made the offer forward are no longer recoverable, right? Which is why this can be a very strong deterrent to pursuing litigation that's really being driven by fees. If you get that number correct, it may be very risky for a plaintiff to go forward, because even if they win, they're not going to get all those fees, or rather their lawyers aren't going to get all those fees associated with taking the case all the way to trial or all the way down the road. So anyway, given that background, in this case, you had a group of former hotel employees. As part of their compensation, they received wages as well as bonuses. When they were terminated by the employer, they were given their final wages, but the employer didn't pay their bonuses or certain bonuses to them. So the employee sued, and in the course of the litigation, the employer makes a 998 offer to this group for $300,000. After making the offer, the employer goes ahead and sends these employees about $75,000 in bonuses, interest, and penalties, and the employees take those checks, they accept that money. The case keeps going anyway, it goes to trial. At trial, the jury rules in favor of the employees, but only awards about $1,200 in damages, all that's left essentially, right? So then both sides go after their cost from the litigation, and the employer tries to use that 998 offer to argue that it's entitled to post-offer costs, because again, it offered $300,000, they only recovered $1,200. That number is lower than the offer that was made. However, in front of the trial court, the court says the cost shifting provision of 998 doesn't apply here because it's basically superseded by the labor code. The labor code sections 206 and 206.5 prevent you from using a 998 offer if you're resolving disputed wage claims, even though you know that there are undisputed wages due at the time you make the offer, right? So here, the employer essentially knew it owed the employees money and didn't just pay the undisputed wages to them. Instead, it waited until after it sent the offer to do so. So in this case, the trial court awarded the employees their costs and found them to be the prevailing party, looking at the fact that they had recovered this additional $70,000, $75,000 as a result of pursuing their case, right? Making them the prevailing party. The decision that came out this year affirmed that decision in front of the trial court. So again, this is one of those things, if you're facing litigation, particularly over wage and hour claims that can generate attorney's fees recovery, that you want to be mindful that some of these strategy decisions, you're going to want to play that out with your counsel and make sure that if you have undisputed liability, that when you pursue things like 998s and other ways to limit your exposure, that you do so in a way that's going to be ultimately beneficial to you. And with that, we've concluded our update. I tried to speak quickly. Well, I always speak quickly, but just to get through everything so that we could give you this update. Of course, you'll all have access to the PowerPoint, and I've been seeing a bunch of questions come in. And so maybe now what we'll do is we'll try and address a few of those questions for our remaining 8 or so minutes of our presentation today.
So I want to address a question that we tried to answer in the middle, which was, does this play with the prior supplemental paid sick leave? And the answer is no. This is a new leave entitlement that applies from the period of January 1st until September 30th of this year. So just to clarify that. So I guess I'll take some of these sick leave questions if that works for you, Liz.
Yeah, absolutely. And I'll go down to the bottom and see if there's anything for me.
So one of the questions is, if we offer 2 weeks of sick leave, can we deduct COVID time off from their sick accrual, or do we pay them as regular pay? And so the answer to that question is, this supplemental sick leave is an additional benefit that is separate and apart from the sick leave that you offer them. And it's really their decision what bank they want to take this leave out of. So hopefully that question is answered. Another question, is the new poster for supplemental sick leave still required to be posted even if the organization has less than 26 employees? And the answer is no, because the law does not apply to you. Wondering your thoughts on whether you count unproctored home tests towards an outbreak under the OSHA ETS. Interesting question. And I think it really would depend on a lot of other facts too, obviously. And I would count them in an excess of caution, because what you wouldn't want to have happen is that you get an audit and Cal OSHA comes after you for not including them or anything along those lines, or your insurer says, oh, you should have told us about this and we're not going to cover you anymore. So I think with respect to those requirements, it's probably better safe than sorry in a lot of circumstances. Let's see. So are rapid tests considered diagnostic tests? I don't know the answer to that, but I can tell you that the types of tests that are acceptable are pretty clearly defined under the Cal OSHA ETS. And so if you go on there and look, it tells you this kind, not that kind information. And I'm just not a doctor, even though I play one on TV. Is SPSL on a weekly basis, monthly basis? So it's on a day-by-day basis, and it's based on, like, if they're out for a day, if they're out for 4 hours, then they have the option, like if they have to go for a test, you know, or a vaccine, it's probably not going to take a whole day. It's probably only going to take a few hours. And so they would, that would apply to them going to get the vaccine or the booster. So it's just used that way as a supplement. Like, they come back the next day and work, you pay them for the next day, and they're just using that portion of the time that they were out getting their test or their booster. So I hope that answers that question.
You want me to take the non-COVID one?
Go ahead. Yeah.
All right, so I see one here. Is there some guidance available regarding whether employers are required to reimburse cell phone and or internet services paid by employees that work remotely? So you know, I'll give you my first lawyer response, which it depends. First of all, we'd have to look at whether the employees are being required to work from home or whether they're choosing to work from home. And then, of course, we'd look at what kinds of work-related resources are being provided to the employee versus that they have to support on their own. And then, generally speaking, we're going to go back to the labor code in 2802, I believe, and look at your obligation as an employer to you know, reimburse for the reasonably necessary expenses of the business. And so it's a complicated question, and you'd have to look at the particular employees to sort that out. And I hope that answers your question, even though I just probably gave you more questions to work through. And then let's see. I see a question up at the top here about non-exempt employees who run work-related errands while voluntarily working from home. what portion of the time spent running errands, including travel, should be counted as compensable time? Well, if they're on work time and as part of their work time, they're doing work things, my initial reaction would be then they should be paid for that time. Maybe it's a more complicated factual situation than that, maybe involving what kind of activities they're doing and if they're mixed with personal things. But really, if they're providing services for the employer, our general, pre-COVID, everything else, we'd look at that as working time. But that's probably the most specific answer I can give given the information in the question. Let's see. I see more COVID, so I'm gonna volley it back over to Cass.
All right, I haven't been dismissing answered questions either, so
I was doing that for you.
I appreciate that. I appreciate that. There's another question that's in the chat, and it's, are we supposed to report to employees the number of hours taken under SPSL weekly, monthly? And the reporting requirement is that it is at the time of their paycheck. So if you pay them on a weekly basis, then you report it on that paycheck. If you pay them on a monthly basis, you better make sure that you're paying them properly, but you would report it on that paycheck as well. Is the new COVID sick leave funded by California or the employer? Well, of course, it's funded by the employer, not the state of California. Though, if somebody has really long-term effects or anything along those lines, there may be supplemental benefits available to them under a state disability or something along those lines. So obviously, if you've got somebody that has a really serious condition going on, then you treat it as a disability and have all your things kick in, because you're probably going to run through the COVID leave pretty quickly if it's a major deal.
I don't know if you got that last one.
I did get that one.
All right.
So I think that's it.
Our list is clear. So before the laws change again, I think we should end this.
I think that's right. And by the way, while Liz was talking, I was surfing the internet because I just can't stay away from the Department of Fair Employment and Housing website. And they already do have guidance up. So you can go and look at that guidance on the supplemental paid sick leave. And hopefully that will be helpful. So that's it. Thanks for joining us.
Yeah, thanks everybody. We'll see you next year, and hopefully we won't be talking about all the same things.